This is a lecture for my professional responsibility class. We're going to be talking about Model Rule 1.8 E3. If you haven't watched the video yet on 1.8 E, the first parts, 1 and 2, that's a long-standing rule. You should watch those before that video before this one. This is about a new change that the ABA made to the rule, adding an exception in August 2020 at their annual convention. So we're going to be talking about the new Model Rule 1.8 E Section 3, which is about providing assistance to indigent clients. Here's the rule. Let's talk about the rule first, and then we're going to hit the highlights from the comments. And before we get going in the rule, I want to mention to my students, this particular rule, 1.8E, is not heavily tested on the MPRE. It's fair game for the MPRE, but it's generally not heavily tested. And this rule change, this new exception, I don't think will be tested until the fall of 2021. So they usually wait a year after a change in the rules to ask about it on the MPRE. Keep in mind, though, that because this is a new change, that your casebooks or commercial study aids for professional responsibility may not have a 1.8 E3, and some of the comments to 1.8 were shifted, were renumbered for the remainder of the 1.8 sections because of this. Okay, here's the rule. A lawyer representing an indigent client pro bono, a lawyer representing an indigent client pro bono through a nonprofit legal services or public interest organization, like a legal aid lawyer, and a lawyer representing an indigent client pro bono through a law school clinical or pro bono program may provide modest gifts to the client for food, rent, transportation, medicine, and other basic living expenses. Again, this is an exception under 1.8E, sections 1 and 2. We would normally prohibit this, but it's an exception for when you're doing a pro bono case for an indigent client. This comes with some prohibitions, some things you're not allowed to do, and make sure you learn these. Number one, the lawyer may not promise, assure, or imply the availability of such gifts prior to retention or as an inducement to continue the client-lawyer relationship after retention. So when a client comes in for a consultation, you're not allowed to say, by the way, if you hire me, I'll give you rent money or cover some of your medical bills, or something like that if you're having trouble making ends meet. You're not allowed to promise this up front before they've made a decision to hire you as their lawyer. Similarly, if the client at some point wants to give up and abandon their matter or fire you as their lawyer and go with someone else, you can't say, tell you what, if you stick with me or you stick with the case, I'll give you rent money or I'll pay some of your medical bills. Second, you may not seek or accept reimbursement from the client, a relative of the client, or anyone affiliated with the client. And so what are we saying here? A gift is a gift. You know, there's no backsies. You don't get to decide later on when your client is, maybe their financial situation improves, that they should have to pay you back for the rent money that you gave them or the money that you gave them to cover their medical bills and so forth. And so no gifts that you somehow decide later on you're going to reimagine as a loan and have the client give it back to you. If you're going to do this, it's over and done. 3, you may not publicize or advertise a willingness to provide this to the clients. And I know this sentence is awkward. The ABA rule was marked up quite a bit with amendments, and so they may touch up this sentence a little bit when it finally appears on their website, but that's the verbiage as it was passed yesterday. And so this means don't put on your website, don't put in your ads, either in an individual client testimonial, oh, I'm so thankful he won my case and he covered my medical bills while the case was pending or something like that, and don't put it out there in your ads, we give rent money or we give some money for living expenses if you hire our firm and so forth. So you're not allowed to advertise it. Again, there was a common law, just so you understand the background here, there was a common law doctrine called champerty and maintenance, which was a prohibition against lawyers offering inducements for clients to go with them instead of someone else. And so that's where the prohibition for 1.8E comes from in general. And we're really just carving out a very narrow exception for indigent clients, but there's still a policy concern from the ABA and many state bars that lawyers are going to use this as a gimmick to bring clients in the door, and you're not allowed to do that. Okay, financial assistance under this rule may be provided even if the representation is eligible for fees under a fee shifting statute. And so I want to point out, you've agreed to do a case pro bono, but it's a loser pays jurisdiction, or there's some sort of statutory attorney's fees, like for certain civil rights actions and things like that. And that is outside the scope of this rule. I do want to tell my students there's a body of case law about what happens. For example, if you do a civil rights case and you agree to do it pro bono and then you win, and now they're entitled to statutory attorney's fees, does that go to you? Are they entitled to any? And I'm going to tell you, go look up those cases. That's not relevant for this video. The idea is that you, under this exception, you've agreed to do the case pro bono, and we're just going to ignore whether you're in a loser pays jurisdiction or we have some sort of fee shifting or statutory attorney's fees in the case. Okay, let's continue. The ABA committees that sponsored this rule change, this amendment, put together a really nice, carefully researched and well-written report. If you're interested in this, I highly recommend it. It goes through the history of 1.8E, the common law history, and also what state bars have been doing about this in recent years. I'm just going to pull out one sentence that I think is actually a really useful one for law students. The new provisions of the rule permit financial assistance for living expenses only to indigent clients, only in the form of gifts, not loans, only when the lawyer is working pro bono without a fee to the client, and only where there's a need to help pay for life's necessities. In other words, you don't just automatically do this for every unemployed client or something like that. Similar exceptions, variously worded, already appeared in the rules of 11 US jurisdictions. So most states, as of 2020, don't have this rule. Hopefully a number of them will recognize it now that the ABA has changed the model rules. Texas, though, has. And so here in Texas, where I teach, they codified a long time ago a humanitarian exception so that lawyers could do this. So we haven't had lawyers getting disciplined for this in Texas, but we have seen lawyers in other states in the last 15 or 20 years, even the last 10 years, being subject to discipline for giving clients, indigent clients, bus tokens to get to court, or helping them cover rent and things like that. And so the ABA wants to allow indigent clients to receive help from their lawyers. Now, the ABA added 3 comments, and as I mentioned earlier in this video, this shifts the numbering or throws off the numbering for comments, old comments 11 and on in Rule 1.8. So if you're using the second edition of the Glannon Guide, for example, or casebooks or old ABA ethics opinions, if it refers to comment 14, for example, it's now going to be comment 17. I'm going to hit the highlights from these, or the interesting points. In comment 11, new comment 11, they I shouldn't say waste, they restate the provisions of the rule and then add this. If the gift may have consequences for the client, including, for example, receipt of government benefits, social services, or tax liability, the lawyer should consult with the client about these rules. And I want to say something about this. If your client is receiving any type of welfare program, cash assistance, it could be a Social Security disability, it could be food stamps or things like that, getting income or a financial assistance from a third party can affect, in some cases, their eligibility to continue receiving those benefits. And or the amount of benefits they can receive. Similarly, if your client's financial situation changes because of your representation, then it's conceivable that your assistance to them could have gift tax implications. And so now you don't have to know all of those right now, but if you're going to provide financial assistance to a client, you should inform yourself about what are potential tax consequences, or find out what government assistance programs they're on and how those might be affected if you're giving how much assistance you can give without affecting it, and so forth. And you have a duty under the rules for communication with your client to explain that to the client. Okay, let's go back to the comments here. Comment 12, paragraph E3, this new exception is narrow. Modest gifts are allowed in specific circumstances where it is unlikely to create conflicts of interest or invite abuse. And then it restates the 1, 2, and 3 prohibitions in this new rule, 1.8 E3. And I want to point out here that if you violate, if, for example, you're promising this as an inducement to have somebody hire you as their lawyer, you're advertising about the fact that you do this or that you're willing to do it or something like that, you could be subject to discipline for purposes of the model rules and therefore for purposes of the MPRE. Also, I understand this comment to say that if your assistance to a client becomes too substantial, it could trigger disciplinary liability under 1.7 for a material limitation. In other words, it could start to cloud your judgment as a lawyer because you've given the client so much money to cover medical bills and rent and so forth. So even if the assistance is permissible here, the idea was that this was an exception that most of the time won't create a real conflict of interest, but watch out, right? We need to keep this within reason. Comment 13, we're almost done. Financial assistance, including modest gifts, may be provided even if the representation is eligible for fees under a fee shifting statute. And then here's the however. This does not permit lawyers to provide assistance in other contemplated or pending litigation in which the lawyer may eventually recover a fee, such as a contingent fee personal injury case or cases in which fees may be available under contractual fee shifting provisions, even if the lawyer does not eventually receive a fee. In other words, this exception only applies if you've offered up front or agreed up front to do the case pro bono. That it's not just the fact that and that you may think, well, it's pro bono until we win, right? Because I might not win anything because it's a contingent fee. That's not pro bono. Pro bono is you've agreed to do it without even getting a fee if the client wins. And they want to make sure that you understand that under the rule. That concludes our lecture about the new rule, Model Rule 1.8E3.